hearing in the appeal of the Scottish General for Scotland against Romein.
Yes, Mr. Dodson.
My lady. My ladies, my lords, in this appeal, Mr. Komorowski and I appear for the appellant and Mr. McBrearty and Miss Irvin for the respondent. As my ladies and my lords will have seen, the case raises a short point of statutory construction. With the court's leave, I'm not intending to go through all the background legislative provisions since, as you'll have seen, they're not in dispute.
Well, the arguments remain as they were, as I understand it.
They do, my lady,
in the
yes.
courts below.
Yes.
So we have, of course, read the judgments in the courts below.
Yes.
And we've read your written cases. So
what I'm proposing to do is simply deal with four points. The first two are directly relevant to the provision which arises in this appeal. That's to say, subsections 3 and 3D of section 4C. Those are the provisions that relate to assumption A, which the court will be familiar with from the written cases. In addition, there are two other points, as the court will have seen, which relate to the wider statutory context. So my third and fourth points will deal with those. That's to say, the first of them, the position pre-1949, and the second, the position post-1983. Before I get onto those submissions, just some very brief introductory words, although I'm, of course, happy to abbreviate them yet further if that would be appreciated. The section with which we're concerned, that's to say section 4C in its 2009 enactment, which is page MS 334 in tab 7 of the bundle. The section, it's clear and it's undisputed, relates to the correction of historic gender discrimination in relation to the acquisition of citizenship by descent. And as the court will have seen, the parties differ only on the effect of a provision in relation to which the respondent claims to have become entitled to British citizenship. So far as the facts are concerned, those can be found in the Statement of Facts and Issues at MS 46. Again, I don't think it's necessary to take the court to them. Perhaps in briefest summary, only this, that the respondent was born in 1978 in the United States, and it's for that reason, the date of her birth, that she comes within the Assumption A area of this legislation. That's to say, somebody who was born between 1949 and 1983. We know, as a matter of fact, that the respondent's birth was not registered at a British consulate, and we know also that the respondent's position is that her mother would have registered it if she'd been able to do so. That point is not a matter of admission, but at any rate, the position is that no registration took place. And finally, on the facts, the respondent applied for British citizenship on the 2nd of May 2013, and it's the refusal of that application that has given rise to the present proceedings. Turning to the particular provision of the legislation in question, as I've already indicated, we are concerned with section 4C on MS 334, which sets out 3 conditions for the acquisition of British nationality, British citizenship by registration for persons born between certain dates. And my ladies and my lords will see that the section sets out 3 conditions. It explains that the person is entitled to be registered as a British citizen if he applies for registration under this section and satisfies each of the following conditions. Now, the first and third conditions are not an issue. They're a matter of agreement. The first condition being in subsection 2, that the applicant was born before the 1st of January 1983. Similarly, in subsection 4, on the following page, it's accepted that the applicant can meet that condition in relation to the right of abode in the United Kingdom. So the only issue before the court is the proper construction of the second condition. And as we see, just turning to subsection 3, we can see that the second condition is that the applicant would at some point before 1st January 1983 have become a citizen of the United Kingdom and colonies. And then the provisions diverge in 3 ways. Paragraph A, under Section 5 or Paragraph 3 of Schedule 3 to the 1948 Act, if Assumption A had applied. And in short, Paragraph A and Assumption A are concerned with acquisition of the status of citizen under the 1948 legislation itself, which came into force on the 1st of January 1949. So it's that with which the court is directly concerned in this appeal. Paragraph B is concerned with the position before the 1948 Act came into force, and the provisions mentioned there relate to Assumption B, which deals with certain deemed matters in relation to the pre-1948 law. And finally, C deals with a hybrid situation where both Assumptions A and Assumptions B might or could be relevant. Either or both could be relevant. And those matters, as Milady and the Chair has already said, are spelled out indeed in the opinion of the Inner House and also in the written case for the respondent. If I could turn then to my first submission, this is a submission dealing with Section 4C, subsection 3, which I've just read. And we can see from the reference to, in paragraph A, to Assumption A, that in order to understand the provision, one has to read it alongside subsection 3A at the bottom of the page. So when it's read in that way, we can see that the question is whether the applicant would have become a citizen of the United Kingdom and colonies under Section 5 or another provision. Section 5 is the one that matters here. If Assumption A had applied, and that assumption is that Section 5, or one of the other provisions, of the 1948 Act provided for citizenship by descent from a mother in the same terms as it provided for citizenship by descent from a father, and references in that provision to a father were references to the applicant's mother. I should perhaps, before I go into this further, remind the Court of the terms of Section 5 of the 1948 Act, which is the provision which is in issue here. And the 1948 Act is tab 11 in the bundle, and Section 5 begins on page MS 347. And we can see, just beginning with subsection 5.1, that subject to the later provisions of the section, a person born after commencement, which, as I mentioned, is 1st of January 1949, shall be a citizen of the United Kingdom and colonies by descent if his father is a citizen of the United Kingdom and colonies at the time of the birth. And then there's a proviso which has 4 paragraphs, provided that if the father of such a person is a citizen of the United Kingdom and colonies by descent only, that person shall not be a citizen of the United Kingdom and colonies by virtue of this section unless. And then we can see paragraph A deals with the birth of that person or his father in certain territories, protectorate, protected state, mandated territory or trust territory, and certain other specified territories. So we're concerned there with the place of birth of the person or the person's father. That's not the provision with which we're directly concerned, which is rather paragraph B. So the person's birth having occurred in a place in a foreign country other than a place such as is mentioned in the last foregoing paragraph, the birth is registered at a United Kingdom consulate within 1 year of its occurrence or with the permission of the Secretary of State later. So it's with that provision and the effect on it of Assumption A that this appeal is concerned. And so before I come back to Assumption A, for completeness, I'll just address paragraph C and D of this proviso. C saying that the person's father is, at the time of the birth, in Crown service under His Majesty's government in the United Kingdom. And 4, that the person is born in any country mentioned in subsection 3 of section 1, in which a citizenship law has then taken effect and does not become a citizen thereof on birth. And the countries listed on page MS 345 in section 1.3 are Canada, Australia, New Zealand, South Africa, Newfoundland, India, Pakistan, Southern Rhodesia, and Ceylon. The point being that this legislation is put in place at the time of establishment of the Commonwealth and at the time when the countries listed in section 1.3 were setting up their own citizenship regime, which might or might not have given rise to citizenship in that country of an individual applicant. So if I could return from there then to MS 334 and how in my submission subsection 3 and assumption A work. My principal submission on this is that on a plain reading of this section, the respondent does not meet the terms of this provision. And that is because her birth was not, in fact, registered in terms of section 5(1)(b). And developing that point slightly, on a plain reading, assumption A is concerned with rewriting the legal consequences of historical facts or events that actually took place, but not with anything more than that. And so returning to the words of the section to explain the basis for that submission, we can see that the second condition is that the applicant would at some point have become a citizen under section 5 if assumption A had applied. So then one asks, well, what does assumption A say? Assumption A says it's concerned with an assumption about the terms in which the legislation was drafted, that section 5 would be drafted in the same terms for mothers as for fathers, paraphrasing it, and references to a father were references to the applicant's mother. So in my submission, if one has regard to the way in which it's structured, what subsection 3 is seeking to do by referring to assumption A is simply to import the legal consequences that would have applied to facts, rather than to ask one to assume that any historical facts that occurred would have occurred differently, if that makes any kind of sense.
That effectively means that any right of citizenship, which under the previous law was dependent on registration, was effectively not created by the more recent legislation. In other words, you require the court to assume that the law was different, but you also are requiring them to assume that at the time officials would have acted on the assumption that it was as it actually was. That's your submission, as I understand it.
My Lord, yes.
Is this a rational thing for Parliament to have done?
In my submission, yes, I will develop the point further, but as Your Lordship will have seen, one of the points that the appellant takes is that to require a decision maker or indeed a court to speculate about what would have happened in the past, possibly even a quite remote past, to require that sort of speculation is a rational basis for saying this is not an area into which the decision maker should be required to go, and where one requires to establish hypothetically that the facts might have been different had the law been different, that is not something that falls within the scope of this section.
Well, there are two possible solutions to this conundrum, aren't there? One is that you assume that because you're assuming that the law would have been different, you're also assuming that the officials would have acted in accordance with the law as we are assuming, rather than the law as it actually was. The other possible solution is that an administrative step, which is dependent on the law as it actually was, is simply no longer relevant if you are making the assumption that the law was different. Now, you, as I understand it, reject both of those solutions.
My Lord, yes, I do. Clearly, it's accepted that the drafting is not perhaps crystal clear, but the basis on which I do so is that when it's put in these terms that the person would have become a citizen had the law been drafted in different terms, then in my submission, in order to make your Lordship's point, one has to tack on to the assumption A that, for example, the officials would have acted differently or the applicant's mother or father would have done something other than was in fact done. And contrary to the point that my Lord has just put to me, what I draw from that is that since that does not appear on the face of the statute, that is not within the scope of the assumption that one is directed to make.
You say the assumption is purely one as to the law.
Yes.
And the inevitable consequence of that is that it's only if citizenship was prescribed by law that, in other words, it was automatic as a matter of law.
Yes.
That anyone can take the benefit of this of Section 4C3.
Lord, yes,
Assumption A anyway.
That is the position which I advance. Yes, and
Whereas Mr. McBrearty is driven to say that the assumption is not confined to a change in the law, but to some extent or other must also involve consequential assumptions about people's behaviour.
Lord, yes, that's in my submission. That's precisely what the respondent's case requires.
He's either driven to that position or driven to the position that the registration requirement is simply irrelevant in circumstances where it would in fact have depended on a view of the law which we are required to assume was wrong. I mean, that second solution is equally something which, I don't think it's the point that he makes, but it is another way out of this conundrum.
Yes, one has to bear in mind, of course, that the registration requirement is there for males as well as for those descending in the male as well as in the female line. So if one were to sweep it away, then one would have to bear in mind that it might carry further than just the issue of gender discrimination that's being addressed by this section.
Yes, I mean, the government's concern is that you're being asked to deal with all sorts of counterfactuals. If the law had been different and the mother was in Crown service shortly before the birth, had she known she would have stayed in Crown service, or
yes.
Or had she been living in one of the protected territories, she would have stayed there. You're saying that is taking the legislation too far.
My Lord, yes, because it respectfully seems to me that once one opens the door of speculating about what might have happened with registration had the law been different, then, as my Lord has just said, there are other factors which there's no reason to treat differently if that is a legitimate course of inquiry.
I wonder about that, because in those cases you were assuming that the would-be, or the parent of the would-be citizen would behave differently, and you're saying no, you don't go that far. In the case of registration, you're merely assuming that if the law had been different, the official would have had to perform in a different way. And in this case, the assertion is that, in effect, an application was made for registration, but she was told you can't do it. It's a much narrower area of factual assumption than the one that I can understand why the government fears.
Yes, clearly cases will vary, so that one may, in some cases, have quite good evidence that a registration was attempted unsuccessfully, and in other cases there will be nothing to go on at all. But I think the concern is to make sure that one doesn't simply make the assumption that registration would have taken place, because there's no, in my submission, there's no good reason to make such an assumption that because the law was is now deemed to have been in different terms, therefore a parent should be assumed to have registered the child.
No, well, you will come on to tell us that 3D forbids
Indeed,
an
yes.
assumption that the parent actually registered the
Yes.
child. Yes.
But for the time being, and perhaps picking up on what my Lord Reid said a few moments ago, the reason, as I submit, and this is in the written case, I'm sure, that the 4 paragraphs of the proviso to Section 5.1 of the 1948 Act are not, in fact, on all fours, is that 3 of them simply depend on the fact of birth in particular circumstances, either in a particular place or to a parent carrying out a particular function. And those are, as one might say, those are automatic cases where, provided one establishes the fact of birth in the particular territory, then the citizenship acquisition flows from that and nothing more. The difference with this case is that it doesn't flow from the pure fact of birth. It flows from birth plus a voluntary act carried out after the birth, which a person may or may not have chosen to carry out. And so it's not it's not automatic, unlike the other examples. And it's for that reason that it's the appellant's submission that this is a case that needs to be treated differently from the other 3. So
but it was a voluntary act which they couldn't perform because of the way the law stood.
My lady, that's correct, yes, they couldn't.
And if you're right about this, doesn't it mean that 3A has to read under Section 5A, C and D? Because you could never satisfy B, except in those extraordinary cases in which, for some reason, registration took place, though it shouldn't have done.
My lady, that would be one way of achieving the legislative result, yes. In my submission, that result is achieved here when one reads subsection 3 together with subsection 3D. So the result is the same. But, so one doesn't need to do it in the way that my lady has described, although I accept that would be a possible means of achieving that end.
Yes, I mean, an issue that obviously we'll need to consider if we are sympathetic to the respondent's argument is that whereas on the facts of this particular case, it may be a fairly straightforward matter for this individual to show that her birth would have been registered if the law had been different, assuming that the evidence she's relying on is reliable.
Yes.
Because there was an actual attempt, effectively, to register it. In a way, I mean, that's an example of somebody whose parents didn't know any better. They obviously didn't know the law and practice, and so they made an ill-informed attempt, which was rebuffed. But what about people who understood perfectly well that there was no possibility of registration and therefore didn't approach the consulate?
Yes.
We're obviously on Ms. McBrearty's argument having to envisage a situation where the consulate would register a birth if asked to do so on this assumed state of the law. But what assumptions, if any, can we properly make about the behaviour of people who didn't in fact apply for registration, but who no doubt whose descendants might say, well, an application would have been made if the law had been different?
My Lord, I respectfully agree that that's a very important, it's a very difficult point, because almost by definition we have no evidence, no material on which to gauge the extent of that problem. But it's plainly important that one shouldn't get some advantage by seeking to carry out an act which at the time it was not legitimate for the consular officials to validate by registration, as compared with people who reasonably acted on an understanding of the law as it currently stood.
I mean, as I understand your argument, you actually pray in aid the anomaly raised by Lord Reid in support of your own case, because you say there shouldn't be a distinction between those who knew the law and didn't apply and those who didn't know the law and did apply but were rebuffed. I think that your argument is that that's one this kind of inquiry is so problematical
Yes.
that it simply doesn't enter into this at all, which is why I invited your attention to the alternative possibility that registration in the case of people claiming through their mother who would have been rejected is a case where one is required to ignore the requirement of registration. One wouldn't do that in the case of people claiming through their father, because the law is perfectly intelligible on that hypothesis.
Well, in my submission, it does, as my Lord has said. It is a factor that points, as I would submit, to the correctness of the approach the appellant advances, because it prevents the anomalies arising to which my Lord Reid has just drawn attention by making it clear that there is no assumption that registration would have taken place, and also by having the effect that there is no differentiation of treatment between the two classes of case which my Lord Reid mentioned. And in my submission, that is, when one's searching for the meaning of Parliament in these provisions, that is an important factor to bear in mind. And so my overall submission on this point is, as I understand the respondent's position, is that because this gives rise to a hypothetical question, therefore Parliament must have intended that that was the sort of question that should be considered. My response to that is that that's not the consequence. The consequence is rather that because of the hypotheticals and other difficulties mentioned by Lord Reid to which it gives rise, such hypothetical questions do not arise for consideration under this section. And so far as my Lord's assumptions point about registration is concerned, if I understand it correctly, it would seem to me that it amounts to an assumption that registration would have taken place. And in my submission...
No, it doesn't, I think, amount to that. It amounts to a suggestion, which I simply throw out for consideration by the parties, that you cannot apply a registration condition at all in a case where registration would in fact have depended on the law as it actually was, and not on the law as we are required by statute now to assume it was. That's the suggestion.
I think I may have addressed that as well as I'm able to, in saying that for the various reasons described in relation to policy and the background of the section, in my submission, the correct understanding, even looking at subsection 3 on its own, is that we are required not to get into these hypothetical considerations about what would have taken place. If I could move on from there to the second submission, which clearly is related, but this is focused directly on the impact of subsection 3D. Subsection 3D is on MS 335. And in the middle of that page, we can see it says, for the purposes of subsection 3, which is what we've already examined, it's not to be assumed that any registration or other requirements of the provisions mentioned in that subsection or in subsection 3B were met. So, as the court will have seen, the primary submission for the appellant on this provision is that, properly construed, what it means is that no assumption is made that registration took place.
Or would have taken
not to be assumed that any registration took place.
Or would have done, on the counter-legal assumption. That's how you read it, isn't it?
Well, in my submission, that's not the appellant's position. The appellant places weight on the fact that it's not to be assumed that any registration requirements were met, and some significance is attached to the use of the words "were met." Were met.
But why is an assumption one way or the other necessary in that case? Because as a matter of historical fact, we can determine whether the registration requirement was met or not. So, you know, the registration requirement in a case to which this applies will, by definition, not have been met, unless there was as Lady Black points out, unless there was some extraordinary administrative error in a British consulate. But that doesn't seem likely to be a sufficiently common state of affairs to be assumed as the background to all this.
Well, in my submission, I think both parties are agreed that subsection 3D is intended to clarify the previous wording of the section, which was enacted in 2002. And in my submission, it assists in that clarification by delimiting the scope of the assumption which has to be made under subsection 3A. And seen in that light, it clarifies, one might say, indeed one would say, if the court were to accept my interpretation of subsection 3, that it's clear that we're concerned only, even looking at subsection 3 alone, that we're concerned only with rewriting the legal consequences of actual historical fact, then it's clear that 3D is not strictly required, but it is nonetheless useful in clarifying the scope of the assumption to the effect that what we're concerned with is making no assumption about what took place. And my submission is that if one is here enjoined to make no assumption that registration took place, and it's common ground that registration did not in fact take place, then the respondent does not satisfy the terms of the section unless one makes precisely the kind of assumption that one is told not to.
But that really doesn't meet the answer against you, the argument against you, does it? Because the argument against you is that nobody's making any assumption that the registration requirements were met. The only thing that they're doing is, one, assuming as a matter of fact, rather than assumption, that it would have been met.
That is certainly the respondent's position. But
yes, so I mean, the would have been is there are 2 points there. One is it's not an assumption, it's just a finding of fact on evidence. And the other is that the finding of fact is not as to what happened, but as to what would have happened.
Yes.
And on those 2 grounds, 3D, it's argued, is not relevant. And if one looks at the actual literal language, which is what the approach you're commending to other parts of this provision, that appears to have some force.
I've said already in my submission that the appellant attaches significance to the fact that subsection 3D itself does not refer to what would have been met, but instead what was met, or requirements that were met. So in my submission, the respondent's position fails in requiring one to ask what would have happened had things been different in the past, rather than simply asking what did happen. Make no assumption, but nonetheless, for the reasons I've already outlined, we're not concerned to ask what would have happened. We're being told here to make no assumptions. And if we're to make no assumptions about what did happen, it seems, with respect, difficult to understand why the Parliament would have thought we should make assumptions about what would have happened.
Well, we're not making assumptions about that. The respondents, are not making assumptions about what would have happened. They're saying they're proving, as a matter of fact, what would have happened.
Perhaps if I could advance my further points on this, I'll attempt to address these various issues as I go along.
Could I ask you, just for really a piece of information, under the 1948 Act, the provision we're looking at, the birth could be registered at a consulate within a year of the birth of date of birth, or it could be registered later with the permission of the Secretary of State. Just wondering, by the time the 1981 Act was passed, did it still remain possible for a birth to be registered?
Wasn't it up to 2 years? I thought it was 1 year as a matter of right, and up to 2 years with the consent of the Secretary of State.
Right.
I may be getting muddled.
Yes. So that doesn't provide that doesn't provide an alternative way out.
No, no, Lord. And indeed, with the 1981 Act, brought an end to the, subject to the transitional provision we'll look at later, brought an end to this consular registration scheme.
Yep.
If I could turn for a moment to the way in which the Inner House approached this provision, as my ladies and my lords will have seen, it was held there that this was a provision about onus, which meant that it was open to an applicant to demonstrate that registration would have taken place had the law been different. And we find that in tab 2, this is MS 198, in paragraph 34. It's simply the summary of the Inner House's conclusions. Subsection 3D simply puts an applicant to proof of his or her claim in that it is not to be assumed that various criteria for entitlement to citizenship were met, and so forth. And indeed, the respondent to this appeal takes a somewhat similar approach, perhaps somewhat more nuanced, but it's nonetheless the respondent's approach, as I understand it, to say that subsection 3D is needed to address the question whether, in fact, the applicant would need to prove anything at all. And perhaps I can just direct attention to that particular paragraph in the respondent's case, which is paragraph 49, MS 88. And in the second half of that paragraph, as I understand it, the respondent's position is that the purpose of subsection 3D, this is about 8 lines up, is not to state that the burden of proof lies with the applicant in circumstances where that would in any event have been obvious. Rather, its purpose is to counter a potential argument that the applicant did not require to prove anything at all in that respect, and makes clear that the onus of proof is indeed on the applicant to show that consular registration would have taken place. Now, in making that submission, as I understand it, the respondent is seeking to rely here on some observations that were made about the predecessor section of section 4C. And I think I should perhaps take the court to this at this point. This is to be found in tab 8 of the bundle, MS 338, the original version of section 4C. And one can see it's drafted in broadly similar terms so far as the opening words and the first and third conditions are concerned. The difference is that the second condition is spelled out much more briefly. And we can see that the second condition is that the applicant would, at some time before 1st January 1983, have become a citizen of the United Kingdom and colonies by virtue of Section 5 of the British Nationality Act 1948, if that section had provided for citizenship by descent from a mother in the same terms as it provided for citizenship by descent from a father. So the points I would make about this are, firstly, as I understand it, the respondent's suggestion is that that wording itself enabled one, or might enable one, to make an assumption that registration would have taken place had Section 5 been in different terms. And I should simply make it clear that the appellant does not accept that proposition. It's my submission that on the original wording, just as on the wording with which we're directly concerned, the question is the same. Can the applicant satisfy the decision maker or court that she would have become a citizen had the law been written in different terms, and nothing else. The second point, a completely neutral point which I should make, is, of course, that we can see that the opportunity was taken in 2009 to broaden out the scope of Section 4C considerably. So that in 2002, in the version we have before us at the moment, the only provision which was an issue was Section 5 of the 1948 Act, whereas in the revised version of 2009, not only are other sections of that Act brought in too, but Assumption B is introduced, which deals with the law prior to the 1948 Act. So that on any view, the draftsman has done a major job of extending the scope of the section in the 2009 version of this section. That point is not contentious, it's purely for information. But so far as the issue between the parties are concerned, I would emphasize that the appellant's position is that neither on this version of the section nor on the one with which we are directly concerned is there any need for a subsection 3D which is concerned purely with the burden of proof. And there are a number of reasons I give for that, all quite short, and I think all flagged up in the case. The first is that it's clear, it's beyond doubt that it is for an applicant to bring himself or herself within the terms of the statutory provision, so that a special subsection introduced into the 2009 version of the section dealing with onus of proof seems to serve no purpose. The second short point I would make is, this is in the case at paragraph 16, there's no reason to introduce a provision about onus purely for the second condition. Because as we know, the third condition, which is not in dispute in this appeal, is about the circumstances in which an applicant could have established that he or she had the right of abode in the United Kingdom. And if one is going to have a provision about onus, it's very hard to understand why one would introduce it to apply only to the second condition in section 4C and not to the third condition as well. And the third point I was going to make at this point, I've in fact already touched on. It's the significance of the words were met as opposed to would have been met. And in my submission, what those point to is that what the section is concerned with is what actually did happen, not things that in other circumstances would have happened. If I could return for the fourth point I have on section 3D, subsection 3D, to the inner house opinion. And this is this time to paragraph 20, which is on page MS 193. I won't read through this because it's quite lengthy, but the point with which I wish to take issue is in the middle of MS 193, where the inner house's conclusion is that on the appellant's approach being advanced in that court as well as this one, subsection 3 would be deprived of all effect whatsoever. And it's my submission that that is a misunderstanding of the way subsection 3D works. So if I can explain for a moment what I understand the inner house to be saying, they're saying that subsection 3D, when it refers to it not to be assumed that any registration or other requirements of provisions were met, that the section would have no effect because one could never assume the fact of birth in particular circumstances or birth to a parent in Crown service. The submission I make is that that is a misconstruing of the section, because although one doesn't make any assumption about any of these things, if, as a matter of fact, the birth took place in a certain territory that meets, say, the terms of Proviso A, or if, as a matter of fact, the birth was to a mother who was in Crown service, so meeting C, then those requirements are met. It's not assumed they're met. They were, in fact, automatically met when the applicant was born in that situation. And so, in my submission, the argument on which the Inner House placed considerable weight to the effect that one cannot get subsection 3D to work if it means what the appellant contends it means is, I would respectfully suggest, misconceived. The remaining points I have on subsection 3D all relate to the question of the hypothetical exercise in which is required to determine what would have happened had the legislation been in different terms. And clearly we've already covered quite a lot of that ground, and I don't wish to labour the point. Indeed, these points are set out in the case, paragraphs 29 and 30. So the fundamental point I make is that it's not maintained that an exercise of that kind would be an impossibility. Of course, a decision maker or a court can form a view about what might have happened in the past. So there's no suggestion that it's a legal impossibility or any other kind of impossibility. But my submission is rather that when one bears in mind, and this touches on the point that Lord Reid raised with me earlier, when one bears in mind the difficulties of dealing with a situation which requires speculation about how things would have happened in the past, or how people who did not do things might have acted had they but known that the law would be deemed to be different in the future. When one bears that sort of consideration in mind, in my submission, that supports the appellant's concern that we are here concerned with actual historical events rather than ones which might hypothetically have taken place had the law been different. Or in short, going back to a point that was put to me at the beginning, this is a rational basis on which one could reasonably take the view that cases of this kind ought not to be treated in the same way as automatic cases of birth in particular circumstances. Such cases require nothing more than a proof of an objective fact of birth in certain circumstances. This case requires something quite different and considerably more.
It might be said against you that the purpose of the legislation we're looking at is to remedy historic discrimination. And on your approach, one of the situations in Section 5 of the 1948 Act, which constituted discrimination, remains unremedied.
Yes. My Lord, I entirely accept that. The issue between the parties is really just the scope, the extent to which this legislation remedied gender discrimination. And I have to accept the consequence of my argument is that it was remedied to a lesser rather than a greater extent. I think the only other point I wanted to make in relation to the hypothetical matters, which I've touched on, is simply to very brief observations on the respondent's point in paragraph 59 of the case, MS 92. I don't propose to go into this in detail, but as my ladies and my lords will have seen, the paragraph 59 sets up a number of examples where it's said a decision maker or a court has to take a view about things that might have happened but didn't actually happen. There's no dispute that that sometimes does have to happen. In my submission, one can't really take much from these examples other than that they are examples in quite different contexts. And they also differ quite notably from the present situation in that none of them arises against the background of a deeming provision that the law was actually drafted in terms different from the terms in which it actually applied at a certain historical period. And in my submission, that would be the important and interesting example if one had such an analogy. But none of these is of that kind. These are all cases about what somebody would have intended to do in the future. One of them perhaps raises the question of what would have happened if one of the parties had not died sooner than would have been hoped. But those are counterfactuals of a very different kind. And in my submission, one can't really place any weight on those for the purposes of the issue before this court. So my submission, in short, is that for the various reasons, some of which bear on the text and the drafting of the legislation, and some of which bear on considerations of workability, properly understood subsection 3D is to be understood not as concerned with the onus of proof, but rather with simply spelling out the limits on assumption A, or indeed assumption B in other cases, the limits on assumption A, and the limits which it spells out for present purposes are no assumption made that registration took place. From there, I propose to move on to the third submission. And this is the submission concerned with assumption B, and with section 4C, subsection 3C, which is MS 335. And I should say, I've said this already, in fact, this is not, as the court knows, this is not a provision with which the present appeal is directly concerned. And the reason for mentioning it is that in my submission, it provides support for the submissions I've already made about how to understand assumption A and the 1948 Act cases. The reason I say that is if you, my ladies and my lords, accept the submission I'll go on to make in a moment, the consequence of that is that for assumption B cases, the earlier cases, consular registration was not addressed by the legislation with which we're concerned, Section 4C of the 1981 Act. So there's, if one wants to put it this way, I probably wouldn't, but if one wants, there's a lacuna in the extent to which gender discrimination is dealt with, both in relation to the post-1948 cases and the pre-1948 cases. And that consistency is the reason for mentioning this subsection as illustrating that the legislator is more likely to have intended to deal with both of those different cases in the same way. So if I could simply remind the court of the terms of the relevant subsection or subsections. The first is assumption B, which is at the top of 335. And assumption B is that a provision of the law at some time before 1st January 1949, as we know that's the commencement date of the 48 Act, a provision of the law which provided for a nationality status to be acquired by descent from a father, provided in the same terms for its acquisition by descent from a mother, and references in that provision to a father were references to the applicant's mother. And at 3C, it's explained that for the purposes of assumption B, a nationality status is acquired by a person by descent, where its acquisition, A, depends amongst other things on the nationality status of one or both of P's parents, and B, does not depend upon an application being made for P's registration as a person who has the status in question. So, as I've said, my submission is that the effect, in particular the effect of subsection 3C, is to cut out cases of consular registration from the scope of the remedial exercise being undertaken in this legislation. And in doing so, it therefore, as I said earlier, achieves the same result as I have described for assumption A.
The argument against you being that consular registration is a different animal from
Yes.
acquisition by registration.
Lady, that's exactly it, yes. And What I'd propose to do is take the court briefly to the opinion of the Inner House. The Inner House rejected the submission I've just made on two main grounds, which are kind of sub-points of the point Milady has just made. The first point it made was that one has to draw a distinction between the word registration, used on its own, and an application for registration. And as we can see in the provision I've just read, subsection 3CB, it's a reference to an application being made for P's registration. So that was the first ground on which the court decided that consular registration was not covered by that because it didn't involve an application. The second point the court made, which follows on from that, is that it identified provisions in the 1914 Act, to which I'll come in a moment, to which it thought the words application for registration could apply. And so by doing that, it sought to give content to the provision. Perhaps it's convenient to take well, first of all, I'll start with the Inner House opinion, if I may. This is MS 195, paragraph 26. And it starts about 6 or 7 lines into paragraph 26. The court notes the inclusion of application is significant. And then there's reference to the 1914 Act, to which I'll come in a moment. And the court says, where provision is made for a person to apply or for an application to be made, that indicates that what is sought may be refused, or at the very least a decision must be made to grant what is sought. By contrast, consular registration, where timus is a matter of right, there are provisions of the 1948 Act relating to the acquisition of nationality by descent, which fit with the requirement for an application and for registration to which Section 4C, 3C of the 1981 Act may be taken to apply. And then the court refers to Section 2 about naturalization, Section 5, inclusion of the name of a child of an alien in the certificate of naturalization, and Section 19 regarding the making of regulations. And perhaps I could most conveniently deal with those 3 statutory references before I look at the wider point in relation to the significance or otherwise of application. To do that, one requires to turn to tab 12, the 1914 Act, which is starts at MS 369. And the provision with which we're first concerned is section 2. It's perhaps simply worth noting, while we are in this territory, that the consular registration provision in the 1914 Act is in Section 1, subsection 1, Roman 5, just near the top of the second page. And it's in terms broadly similar to those familiar from the 1948 Act, with the exception of some dates which are not material for present purposes. So returning, if I may, to Section 2, with the lens, as it were, of understanding whether the Inner House have correctly identified a provision to which Section 4C, Assumption B, can relate, it's my submission that this is not such a provision. We can see that subsection 2 is concerned with the grant of a certificate of naturalization to an alien who makes an application. So there is an application, but the consequence of the successful application is the granting of a certificate of naturalization. And it is not, in any sense, a form of registration. Of course, it's true that one can register a certificate of naturalization, but it's not true to say that a naturalized alien who becomes, therefore, under this legislation, a British subject, it's not true to say that that status arises from registration. It arises from the certificate. So, with apologies for having to keep jumping sections, if one goes back, having looked at Section 2 of the 1914 Act, to tab 7 and to page 335, Assumption B, in my submission, when one looks at the terms of subsection 3C, we can see that, in fact, the Section 2 example is not apposite. It does not fall within subsection 3C. Firstly, because if one's looking at naturalization, then the nationality status is not, looking to paragraph A, is not dependent on the nationality status of a parent. It's dependent on the certificate of naturalization. And secondly, looking to paragraph B, the nationality status for a naturalized person does not depend on an application being made for a person's registration. It depends on an application being made for their naturalization, successful application. So on those two grounds, in my submission, Section 2 of the 1914 Act cannot be what this subsection is directed at. The second example the Inner House gave was Section 5 of the 1914 Act. And if I could invite the Court to turn to that, this is tab 12 again at 374. And we can see here that Section 5.1 provides that where an alien obtains a certificate of naturalization, the Secretary of State may, if he thinks fit, on the application of that alien, include in the certificate the name of any child of the alien born before the date of the certificate and being a minor. So, having regard again to the terms of subsection 3C of the 1981 Act, here in my submission, one could argue that paragraph A is satisfied because the question whether the child is included on the certificate depends on the nationality status of the naturalized parent. So one could say that A is at least arguably satisfied. But it still fails on paragraph B in my submission for exactly the same reasons I mentioned in relation to Section 2, that if we're talking about obtaining a certificate of naturalization, and here for Section 5 we're talking about inclusion of minors within a certificate, we're still not talking about an application for P's registration as a person who has the status in question, because registration is different from naturalization. So in short, my submission is that the Inner House's second example of seeking to give content other than consular registration to subsection 3C of the 1981 Act is inapposite. And their third and final example I can deal with briefly. This is returning to tab 12 of the 1914 Act at MS 382, section 19. Which is simply an enabling power. The Secretary of State may make regulations for certain purposes. A, the form and registration of certificates of naturalization, and C, probably relevant here, the registration by officers in the consular service of the births and deaths of British subjects born or dying, and so forth. But in my submission, that doesn't take one anywhere. It's simply an enabling power to do certain things. It doesn't actually help with the question, what is covered by subsection 3C? And for those reasons, it's the appellant's position that the Inner House has failed, in its opinion, to identify any content for subsection 3C. And that, as I'll come on to explain in my submission, consular registration remains the appropriate content to give to that provision. So if I can turn on to, I think, 4 or 5 short reasons that relate to the issue of whether it's appropriate, as the Inner House does, to seek to distinguish between an application for registration and registration itself. The first point I'd make is that the legislation does not support the analysis in terms of applying for a thing that may be refused or having an entitlement to a thing. One example one could give of that is the opening words of the very section with which we're concerned, section 4C, on MS 334, where it's provided a person is entitled to be registered as a British citizenship if A, he applies for registration, and B, satisfies the following conditions. So it's not a big point, but in my submission it does suggest that to seek to draw a distinction between entitlement and application is not something that should be given great weight, least of all when one looks at subsection 1 in these terms and then is invited by the Inner House on the following page to draw a sharp distinction between application and registration. A second, again, quite minor point is perhaps still worth mentioning, and that is that if one has regard to the terms of the regulations applicable at the time, which are in tab 16, the 1948 registration regulations, I could perhaps just invite the court to look at 2 provisions, starting on page 458. The first one is simply to note that paragraph 2 explains what records are to be kept, so that it's 2A that is relevant for births of citizens born in the district on or after the 1st of January 1949. There's a particular form that one fills in. Unfortunately, it's not in the court's bundle. And paragraph B deals with Form B, which records the births of British subjects born before 1st of January 1949, the commencement date of the 1948 Act. The only other provision which is more directly concerned with the point I'm just looking at is Regulation 5 on the opposite page, which tells one what form entries have to take. And then in paragraph 4, in every case, the consular officer must satisfy himself fully that the national status of the person whose birth or death he is requested to register is such that the registration could properly be effected under these regulations. So first of all, one can see there that the registration only applies to persons having a certain status. But secondly, we can see the description of a birth or death that the officer is requested to register. So in my submission, it's another pointer to the fact that one should not become overexcited about a distinction between application and registration. So that was the first point. The second point is this, that there's no, as I submit, there's no apparent reason for drawing any such distinction. If one considers, what if an application for registration were to be unsuccessful? Well, clearly then it would have no effect on a person's status. So the provision can only be contemplating applications that do result in registration. And if that's the case, then the need for any distinction of the kind that attracted the Inner House falls away. The third point I would make is this, that there's no reason to make provision to exclude the cases to which I've already taken, my ladies and my lords, the cases in the 1914 Act. Because we know that the legislative context here is the removal, as I would say, as in discussion with Lord Reid, the removal of gender discriminatory provisions, albeit with certain restrictions. We know that that is the context of this legislation. But if one thinks about what's in sections 2 and 5, the naturalisation raises no gender discrimination issues at all. So why would one make reference to these provisions when they don't fall within the very purpose that the section is seeking to serve? So fourthly, it's my submission that the reason for the paragraph B reference to registration not being within the scope of the assumption is the same as for assumption A. The fact that registration cases raise an issue that goes beyond the mere fact of birth in particular circumstances and involve the taking of a voluntary step after the birth has taken place. And it may be helpful just to direct the court's attention to the comments of Mr. Fransman in his British nationality law, a short excerpt from which appears in tab 18. And he discusses these provisions in some detail. The only point which I wish to refer to for present purposes on page 479 is in his treatment of 4C, 3CB, which we can see starts about a third of the way down the page. He deals with what's said in the section, and then he makes a reference to what was said in the committee stage in the House of Lords. I should say I disclaim any intention to rely on extra statutory aids to construction. I don't think the courts below found them helpful, and I don't think I wish to trouble this court with them either. But this formulation is a way in which I would be happy to encapsulate the reason for this kind of provision, that certain provisions cover provisions that are about a child automatically acquiring British nationality from the parent, rather than provisions where acquisition would have required an application to be made. And it's pointed out that we cannot now be sure such an application would have been submitted, and even if it had been, whether it would have been successful.
So you can both pray this one in aid?
We could, yes. Yes. So perhaps, as usual, the parliamentary material doesn't really take one much further. But
Very rarely does.
The point I make, which I made already, is that, indeed, in relation to Assumption A as well as this one, is that if one asks why would one seek to cut out consular registration cases, the answer is, as I submit, because they are not automatic. They require one to get into territory about what would have happened in the past had the past been a different place. And that's a rational reason for the legislator to have ruled them out.
It's a pretty weird thing, isn't it, though, to do it in such a roundabout way, and leaving in those people who were actually registered by mistake, as my lady has mentioned. It's a pretty weird thing to do.
I don't think I can disagree with that, my lady. On any view, there are some difficulties in construing this legislation, and no doubt the respondent will point to some in my construction. But in my submission, for the various reasons I've put forward, I've dealt with Assumption A already, but one can reach, if the court accepts the reasons I've just been explaining in the last minutes, one can reach the same conclusion that Assumption B had the same scope, namely that it too took out registration cases. And that, I would venture to suggest, gives some support to the correctness of the construction I've been advancing. Finally on this, this is noted in the case, but it follows on naturally from the point Milady has just made, that I do accept that the construction I've been advancing does involve an overlap for Assumption B cases, between 3C and 3D, because it would cut out registration cases both under subsection 3C, and one might say it would have that effect under subsection 3D. It's not clear, but it might have that effect. However, the key point I would make for purposes of this appeal is that if there is a redundancy, it is in subsection 3C. We still require to have subsection 3D to cover the assumption A cases. And subsection 3C clearly relates only to the B cases. If I could move from there to deal with my final submission, and this one can be quite brief. This relates to Section 9 of the 1981 Act, which is in tab 9 of the bundle MS 340. I can be brief, I hope, because the parties are in agreement, I think, substantially on the effect of this section. The section, as the court will see, relates to a right to registration by virtue of a father's citizenship, etc. And we can see also in subsection 1 that it applies to a person born in a foreign country within 5 years after commencement, who shall be entitled on an application for his registration made within the period of 12 months from the date of birth to be registered if the requirements specified are fulfilled in the case of that person's father and certain other matters. I think it's enough really to take 2 points from it. Firstly, it is a time-limited provision, a point that I think has arisen already. It applies only from the date of commencement of the 1981 Act, which was the 1st of January 1983, for 5 years. And secondly, it perpetuates the gender discrimination under the 1948 Act that we've been discussing already this morning. So that for a transitional period, there is, I think it's common ground, there is continuing gender discrimination in relation to acquisition of citizenship by descent. So, question, why? In my submission, it supports the appellant's approach because it means that registration cases are treated in the same way under this provision as under Assumption A and indeed Assumption B. So one has an entirely consistent regime, 3 different periods dealt with under different provisions, but the same outcome. On the respondent's approach, by contrast, we have a much more generous approach in relation to consular registration. Before this provision was in place, and yet it was narrowed down by this provision, admittedly only for a 5-year transitional period, but it was made less generous than it previously, on their analysis, had been. And the short point I make is that there's no obvious reason why that should be so. There's no obvious reason why one should, on the one hand, introduce a more limited provision in 1981 than, on their analysis, the provisions that had been operative prior to that date. So it's not, I think, the most important point in the case, but in my submission it's relevant only in providing consistency and, in that sense, supporting the submission the appellant makes about the proper construction of Assumption A.
Yes, Section 9, as we see it on MS 340, was there from the outset.
Yes.
Yes. And Section 4C, as amended later, didn't alter.
No, it did not touch it. No.
Didn't touch it. So as I understand your written case, you're saying on a proper construction of assumption B, there isn't scope for altering the facts of the law in relation to registration. The same applies to Section 9, and there's just this period in the middle, 1948 to 1983, which is treated differently. I think that's the point you're making.
That's the essence, my lord, yes.
And you say why?
Yes.
Yes.
Don't have the answer, but that is the problem that the respondent has to address, which is not a problem on the submissions I've been advancing. My ladies, my lords, those are the submissions I would make in support of the motion to the court to allow the appeal.
Thank you very much, Mr. Johnson. Thank you. Mr. Komorowski? Thank you. Yes. Mr. McBurdy.
My ladies, my lords, my intention, subject of course to how the court would wish me to address matters, is to effectively deal with matters in the same order as Mr. Johnson has. In other words, firstly, I intend to deal with what in my submission are the most important elements of Section 4C, those being subsection 3A, read together with subsection 3, paragraph A, read with subsection 3A, and then to go on to subsection 3D. Those in my submission are the more important parts. I'll then go on to deal with the questions of the discrimination, and finally, I'll come round to deal with the question, I think, particularly raised by my Lord Reid. In other words, how is Section 4C to be considered workable? I'll come on to address that finally. So if I could turn firstly to the question of subsection 3, read together with 3A. And it's important in my submission, in considering these particular parts of Section 4C, to bear in mind what the overall purpose of Section 4C is. And in my submission, that is not in dispute. The overall aim of Section 4C is to remedy the historical gender discrimination inherent in nationality law. And when one bears that in mind, it is also important in my submission to analyse what the net result of the appellant's argument here is. Because the argument for the appellant is that Section 4C as a whole provides a remedy for the gender discrimination inherent in all of the relevant statutory provisions, predating 1983, but with the sole exception of those provisions relating to consular registration, and in particular, Section 5.1b of the 1948 Act. So the result of the appellant's argument in my submission is in effect to isolate consular registration, while the gender discrimination inherent in other provisions mentioned in 4C can be remedied. That is not so in relation to consular registration. In my submission, I just make the opening observation that that would be a surprising result in circumstances where the overall aim of the section is, in a broad sense, to remedy historical gender discrimination, and more so in circumstances where Parliament has taken a conscious decision to expand the scope of Section 4C. Because, of course, and I won't take the court to it at this stage, but what we know is that 4C in its original form was very much more restricted. It was concerned only with the period from 1961 onwards, and it was only concerned with gender discrimination which arose through the operation of Section 5. We see the expansion in 2009 through the amendments to the other provisions and the expansion of the period of which it covers. In my submission, it would be a surprising result if one were to limit it and not to give the same remedy in relation to one sole aspect of the previous provisions. Now, given that the thrust of the appellant's argument is to isolate, in effect, consular registration, in my submission, it is striking how Parliament has chosen to refer to Section 5 of the 1948 within the body of Section 4C, and in particular in subsection 3, paragraph A, and subsection 3A. And I think it's a point that perhaps my Lady Black referred to in the course of Mr. Johnson's submissions, because in my submission the important point is that Section 5 is referred to entirely without qualification. one sees that in the first place on the introduction of the second condition at subsection 3, where it's stated, reading short, the second condition is that the applicant would, at some time before 1st January 1983, have become a citizen of the United Kingdom and colonies under section 5 if assumption A had applied. And what we see is a reference in section 5 to section 5 in its entirety. It does not specify only parts of section 5. Conversely, it does not exclude any parts of section 5. And in my submission, by that wholesale reference to section 5, Parliament, through those words, should be taken to have intended to remedy the discrimination inherent in section 5 as a whole. And therefore, the discrimination inherent in each of the different parts of section 5, whether that be through a matter of birth, consular registration, crown service, and so on. And in my submission, once one appreciates the wholesale reference to section 5, one should understand the words would have become, where they appear in subsection 3, in that light. In other words, would have become in my submission does not impute a requirement for certainty which could only be achieved through the operation of law. They are to be understood as being wide enough to encompass would have become in terms of any of the routes under section 5 wholesale. And one sees repetition of reference to section 5 wholesale when one comes on to assumption A at subsection 3A. And again, reading that short, the assumption A is that section 5 provided for citizenship by descent from a mother in the same terms as it provided for citizenship by descent from a father. It is a reference wholesale to section 5. In my submission, that again, for the same reasons as I've indicated, is significant. In my submission, by choosing those words, Parliament has made clear that it is open to an applicant to rely upon all parts of section 5. And in this case, of course, that in my submission leaves it open to this respondent to establish that she would have become a citizen under section 5(1)(b had it provided for citizenship by descent from a mother, and it allows her to do so by establishing that had the law been different, her mother would have registered the birth. If I were to put it another way, very simply, had Parliament intended to exclude the route of consular registration, one would have expected it in this part of the section to do so expressly. It is surprising because Parliament could without difficulty have referred only to those parts of section 5 which an applicant could positively rely upon, or conversely, it could without difficulty have expressly excluded section 5(1)(b). It did not, and it should be understood, therefore, that it was leaving open the possibility of reliance on all parts. I think, if I may say so, it brings me to the point that my lady in the chair raised, that in a sense, and of course one has to look at the whole section and the remainder of it, but it would be a rather curious way of dealing with things, simply to refer to section 5 wholesale, but then to exclude parts of it through implicit wordings in other parts of the section. And my essential point is then that having referred to it wholesale, and apparently given the benefit of it wholesale, one would expect very clear words indeed in other parts of the subsection had Parliament genuinely intended to take away the effect of that reference through, for example, subsection 3b. And in my submission, one simply does not find those clear words when one goes to the remainder of the section. That then brings me to address subsection 3d, and issues are plainly raised as to the meaning of it, the grammar used, and also its overall purpose. And so I intend to address all of those points. But in my submission, it is important to appreciate where subsection 3d lies in the overall scheme of the section. And for that reason, if I might, before coming to subsection 3d itself, if I might draw the court's attention back to the beginning, just to look at the overall scheme of the second condition, where it commences at subsection 3. Appreciating that we've just looked at this already, I again emphasise the points, and it's obvious that this is framed in the conditional. The second condition is that the applicant would have become a citizen of the United Kingdom and colonies. So Parliament is engaging in consideration of what the position would have been if the law had been different. It's unsurprising that it expresses it in the conditional perfect. And one sees that also reflected in paragraphs B and C, where we have consideration of the other circumstances, and the words which are used is would have been under section, reading from paragraph B, under sections 12, subsection 3, 4 or 5 of that Act. If assumption B had applied and as a result of its application, the applicant would have been a British subject. So unsurprising that the whole framework is introduced in the conditional. When one comes to subsections 3A and 3B, one sees that the purpose of those in my submission is plainly to describe what the assumptions are, what one is to assume that the law was. And reading from subsection 3A in the first place, it's introduced, of course, by the noun. Assumption A is that. And what we see thereafter is that the assumption is described in the simple past tense. Reading it shortly, section 5 provided for citizenship by descent from a mother in the same terms as it provided for citizenship by descent from a father. So Parliament, in effect, is inviting the reader to enter into the alternative history, the alternative legal history at this point as to what is to be assumed. In my submission, there's plainly no grammatical difficulty at that stage in expressing that assumption in the simple past tense, not least in circumstances where the past hypothetical has already been introduced in subsection 3. And I accept, for the avoidance of doubt, I accept that in stating that assumption for the purposes of this Act, that is to be taken as an immutable premise. That is not a hypothesis which is capable of being rebutted here. The reader has to continue to assume that to be the case. And one sees precisely the same pattern in relation to assumption B at subsection 3B. The assumption is stated, and again is stated in the simple past tense. When one comes to subsection 3D, in my submission, Parliament is to be taken to have meant, having set out the assumptions at 3A and 3B, it is simply making clear what is not to be assumed, what does not form part of the alternative history. And Parliament simply makes clear in my submission that the factual requirements, unlike the legal requirements, are not to be assumed. But on an ordinary meaning, in the ordinary language...
Why would they ever have been assumed?
Well, I'm coming to that point, my lord. In my submission, if one comes back, reading it shortly, if one looks at the original language, given that we have here in relation to consular registration an additional factor, then it would have been open to reading the original section in a way which, in order to give content vis-à-vis consular registration, could have led the reader to making assumption in favour of the applicant. In other words, there would be an assumption made simply that consular registration did take place if the mother had been in a position to go that far. The point, and I'll come back to if I may, Lord, is in my submission perhaps highlighted when one compares and contrasts how the matter is framed in terms of section 4C compared with how consular registration is referred to in section 9, which we've looked at for other purposes. And there is in my submission room for confusion which may have been thought to be require addressed. I'll come back to expand upon it if I may, my lord. So, section 3D in my submission, an ordinary meaning of the words, simply means that nothing is to be assumed, but it does not preclude the applicant from establishing those requirements or facts. And if I were to apply it in this way, just taking the Oxford English Dictionary definition of assumed, which is taken for granted, it simply is to be read as, for the purpose of subsection 3, it is not to be taken for granted that any registration or other requirements were met. And in my submission on that ordinary reading of the language, it is not to be assumed, but equally it leaves it open to the applicant to prove the matter. The grammar in my submission, the point is made by the appellant that the grammar is used is in effect the simple past tense because one sees at the end of it were met, referring back to requirements in the plural. And as I understand it, the point which has been made is that given we're in the territory on the respondent submission of considering the past hypothetical of consular registration, it is said that one would have expected it to be in the conditional, would have been met. In my submission, one requires to read subsection 3D in the overall context of the section. Whereas in my submission, the use of the past simple tense there is in effect simply mirroring the past simple tense which one sees at subsections 3A and 3B. As I've already pointed out to the court, unsurprisingly, assumptions A and B are stated in the past simple tense. There's no difficulty with that. Parliament having told us at assumption A and B what is to be assumed, it's at 3D simply telling us what is not to be assumed. And in my submission, the use of the past simple tense mirroring what's already gone before in the remainder of the section is entirely unsurprising. In fact, it might have been more surprising if, rather than that, Parliament had stepped back into using the conditional at 3D. All in the context, of course, that it's to be remembered that the conditional and the use of the conditional perfect already arises at the very outset of the second condition at subsection 3. So in other words, the conditional is introduced there, and thereafter at 3A, 3B and 3D, Parliament is simply describing what is to be assumed, what is not to be assumed. It's unsurprising in my submission that they've chosen to use the past simple tense in describing each of those matters. And of course, it's unsurprising when one then comes to an entirely new condition at subsection 4, we see Parliament reverting back to the conditional. The third condition is that the applicant, reading short, would have had the right of abode had he become a citizen. So one is then at that stage into a new condition. It plainly requires the conditional, and one sees a change then from the wording of 3A, 3B and 3D into the conditional at 4.
I'm just thinking aloud, but if that weren't the position and Mr. Johnston were correct, then the effect of were met in the indicative would be, I think, to knock out all cases under Section 5(1)(b of 1948 Act, unless there had, in fact, been registration of a child born to a mother who was British by descent.
By mistake.
And yes, a mistaken registration. And at the moment, I'm struggling to see any rational ground for giving those people preference over others, because it wouldn't be any reliance or legitimate expectation engendered by the registration, because at the time nobody would have imagined that British citizenship flowed from it.
My respectful submission, to give preference to that category would in fact be entirely arbitrary, because if one considers it in this way, it is plain Mr. Johnson took the court, of course, to the regulations, which are relevant at the time from the 1948 regulations, which indicated that it was not possible to lawfully register. So if one were to consider it in the way in which my Lord Reid suggests, it would be given to give preference to a category of applicants who, by dint of error or good fortune or persuasion of a consular official, for whatever reason, were able as a matter of fact to register, but nevertheless in a manner which was still unlawful, didn't have any lawful effect.
Would the registration have been legally effective if it was unlawful? Assume a registration of an unqualified person by mistake. Would it have been valid in law?
In my submission, it would not have been valid in law. It may have taken place as a matter of fact, but on the basis of the law as it then stood, it had no legal effect and ought to have no practical consequences.
Yes,
in fact,
this Act would give it legal effect.
Yes.
But you say, why give preference to such a subgroup? Yes.
Why indeed? And in circumstances where it would be entirely arbitrary and one would be giving preference to a group where, in effect, the mother had, for whatever reason, been able to factually, as a matter of fact, consularly register, and yet that would displace those who the mother might have positively intended to and tried to, such as the respondent's mother states in her affidavit she did in this particular case, and yet was unable to. It would be an entirely arbitrary matter, and it would be a very odd way in my submission to make a distinction on the basis of the interpretation of the statute. And in a sense, it would be almost the matter was raised at an earlier stage. It's fallen away because it's not been directly part of the appellant's case. But the point was made that in a sense, it might even have given rise to questions under Article 8, possibly in conjunction with Article 14, because it would be, having established a law of citizenship, one would take the point that it ought not to be applied in a manner which is discriminatory due to other status, because the difference in status would be one between, on the one hand, those who by good fortune were able to factually register, and those who were simply unable to, whether they tried or whether they were unable to, or so on. It would be an entirely arbitrary other status. So in my submission, it focuses in that way.
Can I just ask you about the legislative history of this provision? The previous provision was the one at page MS 338, is that right?
Yes, my lady.
And that was very simple.
Yes.
Because you, the technique seems to have been to, in the revised provisions, make the, leave section 5 in untrammelled without taking out of it in any way subsection B. And then by means of subsequent provisions to remove it. But none of that was done in the original 4C, was it? It was just a very plain, simple provision, would have become.
Would have become, my lady, and I think I'm coming on to address this in terms of the purpose to 3D, which is what I'm about to address. Of course, the complication goes beyond simply, I think, the one that your ladyship has addressed, because one has to bear in mind that Parliament has had regard to bringing in these other routes to discrimination and so on.
Right, but what I was trying to get to was that it was meant to widen the improvement, not narrow it.
I respectfully agree with that, and I think it was a point I sought to make at the outset, that when one looks at the legislative history, and one could trace it back further, because one sees, of course, prior to Section 4C, one had the operation of the Rees policy, which the court will have seen reference to both in the Inner House decision and also in the papers before it, because the Rees policy came into effect in 1979. That was simply a statement in Parliament by the then Home Secretary, and it effectively was a matter of his discretion that he was prepared to grant citizenship to a certain category of minors, but of course it was a discretionary grant of citizenship under the powers then available to him. And by definition, because of that, it only traced back to 1961, because in 1979, it could only have effect in relation to minors who were born at the latest in 1961. So one has that. The Rees policy continued to be brought into effect, continued to be affected after the introduction of the 1981 Act from 1983 onwards, but by necessity became defunct as in 2000, because at that stage there were no more minors who were born after 1983, who otherwise would not have been touched by the 1981 Act. So it's in that context that one sees Section 4C coming into place in my submission. One sees Section 4C being brought in with the Rees policy having become defunct. And it's for that reason when one looks at MS 338, one sees the original form of 4C is still restricted to those born after 1961. It was effectively an arbitrary, in a sense, an arbitrary date, because it simply mirrored what the Rees policy had stated. And it having been recognised that, firstly, Section 4C in its original form was limited to that extent. In other words, it was limited in that it only went back as 1961, and also limited in that it didn't deal with all of the other provisions, Section 12 and so on. What we have by way of amendment in 2009 is an expansion. We have an expansion of the overall effect of Section 4C. And my submission comes to be that in those circumstances, the short point is that when we otherwise see not just Section 4 being an attempt to remedy historical gender discrimination, but to widen the scope of what was enacted in 2003, that is consistent with the respondent's position that one should understand provisions such as 3D as being ones which are consistent with that expansion, rather than being an anomalous provision which, despite that overall aim, leads to a limitation. I'm not sure whether I answered the lady's question or not. But the purpose of 3D, and this I think comes on to the point raised by my Lord Sumption. The point made by the appellant, of course, is that if it is to state that the burden of proof is on the applicant, then why is there a need for subsection 3D at all? Because one would always, the position would plainly be that the onus is on an applicant to bring themselves within the terms of the section. In my submission, it should be read as making clear that the onus lay on the applicant, not just in relation to the matters of registration, because the court will be aware that subsection 3D refers to all other requirements. So it's making clear that the onus is on the applicant, in my submission, in circumstances where that might otherwise have been open to doubt. Now, having just looked at section 4C in its original form at MS 338, that is the provision, of course, which one has to consider in having regard to whether it was open to any doubt. That is the position as it was. And the short point that I make, and I'll come on to contrast section 4C with section 9 in a moment, but the short point which I make is that on this coming into force, one sees in the original form that, as in the current version, that section 5 is referred to without qualification. So if one takes that starting point, the reader is invited to consider section 5. He or she is invited to consider, therefore, not just section 5.1a, c and d, but also section 5.1b. In my submission then, there is a legitimate question raised as to how the second condition, as there stated in the original version, was to be given content with regard to consular registration. Because, of course, as we know, the other requirements, for example, Crown service, the place of birth, and so on, simply state one single requirement, which could have been met as a matter of fact. It effectively sets out a state of affairs and consideration of whether that could be met. Section 5.1b, by contrast, is obviously different. It involves a further question beyond that. It involves the question of whether the birth was registered at the consulate. So in my submission, a legitimate question on reading 4C in its original form is, how was it to be given meaning insofar as it related to section 5.1b? And in my submission, it was at least open to being interpreted when looking at subsection 3 together with 5.1b itself, because of course one has to look to that. It was open to being interpreted as meaning that within the alternative history being postulated, in other words, that section 5 as a whole was gender neutral, it was to be assumed that the requirement of consular registration was met. In other words, that would proceed on the basis that implicit within the words would have become in subsection 3, when read together with section 5.1b, was the assumption that those mothers in a position to consularly register would have done so. Now, the point is perhaps highlighted if one is to contrast the terms of section 4C in its original form with the terms of section 9. And before I go on to section 9, I simply reflect on the fact that MS 338, section 4C, of course, what we see is the reference to section 5 in the conditional again. We have it stated in the conditional. And there is no doubt that on any view, what requires to establish is whether the applicant would have become a citizen. So there is consideration of that further question. Section 9, of course, and it's to be found at MS 340, before I take the court directly to the particular terms that I draw attention to. Section 9, of course, is the provision we've already discussed, and Mr. Johnson's discussed with the court. It's the transitional provision by which Parliament, in effect, gave continued effect to consular registration, that system, for a period of 5 years. And I accept, of course, that by doing that, Parliament in 1981 took a conscious decision to continue with an element of discrimination for that 5-year period. What is notable in my submission is how that was achieved, because it was not achieved by continuing, as a matter of fact, the system of consular registration. It was achieved by imposing an assumption, by which I mean a positive assumption in terms of those who might have been consularly registered. One can see that in my submission if one reads the terms of section 9, subsection 1, a person born in a foreign country within 5 years after commencement shall be entitled in their application for his registration as a British citizen made within the period of 12 months, and so on, to be registered as such citizenship, a citizen, if A, the requirements specified in subsection 2 are fulfilled in the case of that person's father, so we don't need to trouble with that. the provision which I'm interested in is paragraph B. And if I could just ask the court, rather than me reading that out, if I could ask the court just to consider the terms of B for a moment. The simple point I make is that, in a sense, it breaks down into two parts. The second part, which is the part concerned with the right of abode, reading from the fourth line from the foot of B, starting with he would immediately before the commencement have had, is stated in the conditional. It's a conditional requirement regarding the right of abode. By contrast, the first part of that section, which deals expressly with consular registration, is not so stated. It states, had that person been born before commencement and become a citizen by virtue of Section 5 of the 1948 Act as a result of the registration of his birth at a United Kingdom consulate. And then one comes on to the conditional part, which only arises in relation to the right of abode. And the simple point I make is that what we have there in the 1981 Act in Section 9 is a provision in which consular registration is referred to by way of a positive assumption in favour of the applicant. Now, the reason why I say it perhaps provides content for the introduction of subsection 3D is that I recognise if this had been a provision which was live at the same time as section 4C, it might be a point against me, because one might say, well, one can draw a distinction between section 9 on the one hand and section 4C on the other hand, and one can understand that section 4C should not be taken to involve an assumption in favour of the applicant. But it is notable in my submission that section 9 was repealed by way of the very same act which brought section 4C in its original form into force. And in fact, section 9 was repealed prior to the introduction of section 4C. Your ladyships and your lordships will see that from the heading to section 9 that section 9 was repealed on the 6th of November 2002. For the avoidance of doubt, that was by way of the Nationality, Immigration and Asylum Act 2002, Schedule 2, paragraph 1C. By contrast, section 4C was brought into force by way of statutory order by the Nationality, Immigration and Asylum Act 2002, commencement number 4 order 2003/754, with effect from the 30th of April 2003. So in my submission, it is a point which adds some weight to the respondent's position, which is that in circumstances where previously, within the same act, one had consular registration being referred to in terms which involved a positive assumption in favour of the applicant, and yet being read in slightly different but a subtle difference between this term in section 9 and how one sees it in the original form of section 4C. In my submission, it is a matter which could at least have given rise to doubt and gives one an explanation as to why it was thought appropriate to introduce subsection 3D in the terms in which it was introduced. The intention beyond in subsection 3D, in other words, was an attempt to put the matter beyond doubt, that it was not to be assumed but open to proof. I accept, of course, if that was the intention, it appears to have been an ill-fated attempt, given that we find ourselves here discussing it. But nevertheless, in my submission, it doesn't detract from the force of the point. In other words, the short point I make is that this is not simply stating that the burden of proof is in the applicant in circumstances where it would have otherwise been free from doubt. It is clarifying that indeed the applicant does have to establish the matters of fact which are prerequisite to the entitlement to citizenship. Now, I also draw attention to the fact that when one considers subsection 3D, one has to take into account that what is not to be assumed is not just the consular registration provisions of section 5.1b, nor is it even simply the consular registration provisions both pre-1949 and post-49. It's in fact what is not to be assumed is that any registration or other requirements of the provisions mentioned in subsection 3 or subsection 3b were met. So it is a reference to whatever it's meant to be. It's plainly a reference to all of the provisions which are mentioned above. And if I might just address that in two ways, because it does raise two questions in my submission. The first is, what effect, if any, does that have on the purpose to 3D, which I've already advanced submissions on? Does it affect the purpose which I contend for? And secondly, how, if at all, does it affect the interpretation of 3D as a whole? And if I could deal with those in turn. Firstly, it's plain on 3D that it refers to registration provisions both pre and post 1949, because one sees it's not to be assumed that any registration, if I was to read it shortly, it is not to be assumed that any registration requirements of the provisions mentioned in that subsection, namely subsection 3, or in subsection 3b, were met. So one sees that it incorporates a reference to all of the consular registration provisions. And of course, we know that that has content in my submission because the consular registration requirements existed prior to 1949, just as they existed in section 5.1b. And for the avoidance of doubt, of course, the court, I think, knows that the pre-1949 provisions were firstly section 1, subsection 1b, Roman 5 of the British Nationality and Status of Aliens Act 1914. The avoidance of doubt, the court will find that. I don't intend to take the court to it, but it's to be found at tab 12, MS 371 to 372. And the second of those pre-49 consular registration provisions is section 1, subsection 2 of the British Nationality and Status of Aliens Act 1943. The court finds that at tab 14, MS 391. And either of those provisions, either of those routes in my submission under 3D would be a registration requirement of the provisions mentioned at subsection 3b. And it clarifies in the same way as it clarifies the matter in relation to section 5.1b, it clarifies the matter in relation to those pre-49 provisions. But I also recognise that in choosing to insert subsection 3d, Parliament has also referred to the other requirements of the provisions. It is not to be assumed that any registration or other requirements of the provisions mentioned in that subsection or subsection 3b were met. My submission, the natural meaning of other requirements of the provisions, those provisions being everything else referred to above, is everything else that those provisions require. So it would therefore include Crown service, it would include birth in a particular place, a protectorate, so on. In other words, none of those requirements are to be assumed. The applicant must establish each of those requirements just as he or she must establish consular registration. Now, I recognise that I introduced the purpose of subsection 3d by saying that the purpose of it was to clarify a doubt that might otherwise exist in relation to consular registration. And I recognise that on that view which I proposed, the same doubt might not exist in relation to the other requirements. One might assume that an applicant would always have to establish Crown service or the place of birth and so on. But the answer may be this, simply that in enacting subsection 3, if Parliament had restricted subsection 3d only to the registration requirements, it would have created a whole other problem. Because what it would have stated that it was not to be assumed that the registration requirements were met. If it had been silent regarding all of the other requirements, it would have given rise to a different potential problem. Because by silence in relation to the other requirements, for example, take an example of Crown service, it might have left open the confusion because the wording might have suggested that those were to be assumed. In other words, registration requirements were not to be assumed, but Crown service is to be assumed. And in my submission, whilst the issue is perhaps most closely focused in terms of consular registration, it would appear that Parliament has simply taken the opportunity, therefore wholesale, to clarify the matter that none of these requirements are to be assumed. But it is notable in my submission that in doing so, it has sought fit to make express reference to registration requirements. It hasn't simply stated all of the requirements of the provisions above. It has made express reference to registration requirements and a catch-all of the other requirements. And in my submission, one can readily see in those circumstances, if there was an original doubt about the content of Section 4C as it applied to consular registration, there was perceived to be a need to clarify it, but then once someone comes to clarify it, it's easier not to create greater confusion and simply to apply subsection 3D to all of the requirements. So in my submission, the short point, the fact that other requirements is mentioned in addition to registration requirements does not detract from my submission as to what the purpose of 3D should be taken to mean in the first place.
But the things that you are not going to assume by virtue of this provision are qualitatively different. One category is something that you could have done but chose not to. You might have made a different choice if the law had been different. The other category is something that you could not have done, register. And so in that second category, you're saying that when the application's made, there has to be a look to see what the family would have done, but not in relation to the other matters?
No, equally so, my lady. There would at least have to be an investigation. The applicant would have to establish what's made plain by 3D in my submission is that this requirement for the applicant to prove these factors applies to all of them. So the applicant just as, and I don't think we're differing that, the appellant and respondent, there would be a requirement to establish as a matter of fact, for example, that the mother was in Crown service at the time.
That was, but I'm talking about would have.
Precisely.
So that if the law had been different, she might have stayed in Crown service until the baby was born, for example.
Yes, I take your ladyship's point.
Supposing they allowed married women who were
Well, I
pregnant
was
to stay
thinking
in
that.
Crown service at that date, but there we go.
Stayed living in a place was probably a better example.
I had intended to address this expressly in
by all
relation to the overall question of how one works Section 4C, because it seems to me that it expands into that territory. I mean, there are two answers to it in essence.
By all
but
means, wait until you're ready.
If I may do so, but I'm very happy to deal with it now if my lady prefers me to do so. But I'm alive to the issue, my lady.
This may be another point that you propose to deal with in due course, in which case don't let me take you out of your course. But, I mean, your submission implies that somebody who knew the law and realised that it would be pointless to apply for registration because it would be rejected under the law as it then stood, would not benefit by the new legislation. Is that your submission?
No, that would not be my submission, my Lord.
Right.
And again, I do intend to come to address that. The short answer is of course, each application was required to be determined on its own
But
facts.
such a person would not have, as a matter of fact, have acquired British nationality because no application would have been made under the law as it then stood.
But I think your case is, but had the law been as it now is assumed to be, the question is, would they have taken advantage of
Precisely
it?
so. In other words, there would be no distinction in my submission between, on the one hand, the respondent in the present case, whose mother actively says, I was so interested in the point, such was my interest and my determination to obtain British citizenship for my daughter, that I made a positive inquiry to the consulate and received a negative answer, plainly in territory. That there may be, in fact, there may be those who, I mean, for all one knows, there might be those who have a written record of a letter sent to the consulate which would record that. There would be no reason in my submission to distinguish between that category of person on the one hand, and on the other hand, the category of person who says, I was interested in obtaining British citizenship, but as it happens, I was very well informed. I didn't make an inquiry to the consulate because I knew what the position was. I understood it perfectly. But
How would you ever prove
would
that?
have become.
I mean, as a matter of practical reality, if you assume somebody who doesn't need to make any inquiries because they know perfectly well what the rule is, how would you ever prove what he would have done about a possibility that was never open to him and about which he therefore never had any reason to reflect? I mean,
Well, with respect, my Lord, I'm not sure that the last part of that necessarily follows.
Well,
simply because he or she knew of it, that he would not have reflected. And in fact, we're talking she, of course, here, that she wouldn't have reflected on it. Because
you're positing a class of persons who know that there is no hope of obtaining British citizenship and who have asked themselves, what would I do if there was a hope of obtaining British citizenship?
Well,
That seems a very strange inquiry to make.
If it is a strange inquiry, my lord, in my submission, there are bound to be strange inquiries on the face of what is a very unusual statutory provision which requires this kind of resurrection of past statutory provisions. It inevitably brings one into hypothetical questions such as this. The point is made, and to some extent I'm moving ahead, but the point is made is that in many circumstances the Secretary of State, and of course the courts, because I make the point here that these requirements of fact are not matters for the Secretary of State to ultimately determine. These are matters which are simply a route to entitlement to registration as a citizenship. If the Secretary of State decides it in one particular way, it is not determinative. It's simply a view that the Secretary of State arrives at. It is always possible for an applicant in these circumstances to come to the court and seek a declarator, effectively to say that it would have happened, in the same way as all sorts of other hypotheticals in the laws of immigration and asylum, nationality and so on are open to treatment in the same way. And so the matter might be addressed by saying, well, how would your ladyships and your lordships deal with it if they could think of themselves as a judge sitting at first instance? How would they treat it? And in my submission, while it is an unusual past hypothetical, it's perfectly capable of resolution on a balance of probabilities. And if I were to posit this in answer to my Lord Sumption's question, if one considers what would an affidavit from a mother in those circumstances say? Well, it might very well say virtually all of that which has been said by the respondent's mother here, with the exception of the punchline, because what it might say is, yes, I moved to South Africa. It was enormously important to be us. Our British ancestry was enormously important to us. I was British. My father was British. We regarded that as very important. I was very keen indeed that my children should have British citizenship if it was at all possible. But I knew that it wasn't possible. So I made no inquiry of the consulate. But given my knowledge and given the importance to me of being British, had the law been different, which I would have known about, given I knew that the law was against me, I would have known if the law was with me. And in those circumstances, without doubt, in my view, subjectively, I would have made an application. I would have sought to consularly register. With respect, it seems to me, if a single judge testing that, and indeed it follows if the Secretary of State were to be testing that, there's no reason why that could not be determined in favour of the applicant. And equally, I think the point's made by the Secretary of State that how would one test that to the contrary? Well, there are circumstances in which it would be open to the Secretary of State to doubt that, because, and it would depend on the application, each and every application would be different. But take, just as one limited example, there are countries, as I understand it, of course I don't profess to be an expert in nationality law of other countries, but it appears that there are other countries which pose an absolute ban on dual nationality. And so
the United States did for a long period of time.
They did for a long period. I don't think I can say that they don't because I know my children have dual nationality, so I can authoritatively state that much. I think Poland is an example. China would be an example. There are examples out there. Equally, there are countries which pose a ban on dual nationality, but only in circumstances where the holder of the citizenship of that country has taken the second citizenship voluntarily. So an example of that would be Holland, for example. They have no difficulty with dual citizenship, provided that it's been taken by operation of law. They do have a difficulty with it if it's taken voluntarily, and query into which category consular registration as a direct and voluntary act by the parent would fall into. My point is simply this, is that in such circumstances, take a hypothetical example, a mother living in Poland, which doesn't allow dual nationality, married to a Polish national, father who's a Polish national, in a family with other siblings, for example, who are well settled in Poland, and there is a possibility that if the mother consularly registers the child, it would have effect on that child's citizenship of Poland, the country in which they're settled. Now, it's a hypothetical example, but it would be open to the Secretary of State in those circumstances, where the mother now comes and says, well, in 1981, I would have consularly registered the child, to say, well, we don't accept that because there was a compelling reason why you wouldn't have done. because we know that you are living in Poland at the time, you continue to live in Poland, and that would have had a striking effect on the citizenship rights of your child who was born in Poland and living in a settled environment. Now, it's an example only, but I simply draw it out in order to say there is another side to the coin. The Secretary of State is not simply required to sit back and accept at face value whatever is said by an applicant. And equally, one could envisage circumstances where it becomes very difficult for an applicant to prove what the mother would have done at the time. Straightforward example, if the mother is deceased. Now, well, plainly that becomes an obstacle to the applicant in proving it. Not insuperable, it would depend upon what the applicant, his or herself, have to say about it, but it would be an additional obstacle. And the point comes to this in terms of how it is intended to work, that it simply depends on the facts and circumstances in every case. And if the courts were able to deal with that, as they may have to, if the applicant decides to test it before the courts because they don't accept the Secretary of State's view, then in my submission, the Secretary of State equally can deal with those matters. I think that's addressed while I'm dealing with that, I've effectively dealt with the question of how Section 4C works, absent, I think, the question that my Lady Black posed. And I think it might be as well for me simply to take that point now.
And are you going to come to subsection 3C at some point?
I am indeed, my Lord, yes. I'm coming back to that. I'm simply recognising that I'm now in the territory of having addressed the questions about how Section 4C worked. I may be as well to tie off that chapter by addressing the question that Lady Black posed to me. As I understand it, and forgive me if I've misunderstood, but I understand that the point that my lady has raised is effectively the one which the appellant says is that once one opens up to the past of what would have happened, where does one stop, in a sense? Where does one stop? Is the Secretary of State then obliged to consider all sorts of other past factual hypotheticals, such as ones relating to the third condition, the right to abode, ones relating to whether a mother would have stayed in Crown service expressly in order to ensure that the birth took place within a protectorate, for example. Now, I think there are two answers to that question. The first is, and I'll take them in effect in reverse order, well, if the Secretary of State is obliged to engage in such inquiries, then in my submission, the opening up of those other past hypothetical questions is not such a significant difficulty as to detract from the construction contended for by the respondent. On any view in my submission, there must be very limited circumstances in which such hypothetical questions could even arguably arise. No doubt they would be very difficult to prove, but if they require to be considered by the Secretary of State, then the Secretary of State is perfectly capable of determining those in the same way as the question of past consular registration. So, in a sense, that response to the question is, without being disrespectful to the position, is a so what kind of answer. Of course, they can be dealt with, and the limited nature of the inquiries that might ensue, one could see that when one looks, for example, to the right of abode provisions, there would be very limited circumstances in which any past hypotheticals would arise. For example, looking to the right of abode provision, MS 395, and this, I think, is the provision which the appellant is most concerned about, because what is said is, well, what happens if we require to consider the past hypothetical of whether they would have sought to reside in the United Kingdom for longer in order to fall within the ordinary residence category at subsection 3, section 2, subsection 1, paragraph 3, C, my apologies, because that's the requirement for ordinary residence, which would get an applicant in the door to the right of abode. But of course, it's very unlikely that anyone certainly involved in consular registration need get as far as that, because almost certainly they'll fall within subsection 1, paragraph B, Roman 2. Because subsection B is the requirement that the person is a citizen of the United Kingdom and colonies, born to or legally adopted by a parent who had that citizenship at the time of birth or adoption. Now, by definition, anyone by descent, their parent will satisfy that. They will satisfy that category. And then they fall into either one, then had that citizenship by his birth, adoption, naturalisation, or except as mentioned below, registration in the United Kingdom or any of the islands, or two, had been born or legally adopted by a parent who at the time of that birth or adoption so had it. And in my submission, on any of those views, an applicant for citizenship by descent will almost certainly fall into one of those categories. The likelihood of ever entering into the past hypothetical about ordinary residence in my submission is remote. But if it's necessary, then in a sense, so be it. And equally, how else might it arise on the Crown service, or take, for example, the place of birth example. That would be a section 5.1a example. Would the mother have stayed longer in northern Rhodesia in order to ensure that the child was born in a protectorate? Well, it seems to me to be respectfully unlikely that very many of those applications will come up. If they do come up, then there's no difficulty with the Secretary of State dealing with it in the same way as she requires to deal with consular registration. And equally, there would be no difficulty with the courts dealing with it if they require to reach a determination on whether or not that would have occurred. So that's one response to it. The other response is simply to say this. Because consular registration, particularly through 5.1b, is open to reconsideration in terms of what would have happened, it does not necessarily follow that all of those other past hypotheticals are equally open for reconsideration. And the reason why I say this is that of all of the provisions falling within section 4c, and in particular within subsection 3 and subsection 3b, section 5.1b is the only provision which, when one applies the law in a gender-neutral manner, gives rise in terms to a hypothetical question. It's the only one which, in the express terms of the legislation, assuming that it had been applied in a gender-neutral manner, gives rise to a past hypothetical in terms. The other provisions simply give rise to a question of a state of affairs, whether it would have existed or not. And moreover, I emphasise that the past hypothetical in section 5.1b not only arises in terms, but it's one which, in its own terms, involves discrimination. Because as we know, it was not possible for the mother to lawfully register the birth at the relevant time. So it's a past hypothetical in terms, and it involves an element of discrimination. Now, if one were to read, and I don't think I require to give a determinative answer on this, but if one were to interpret section 4c to give effect to its purpose, in other words, to remedy historic gender discrimination, then in my submission, it would be open to the court to determine that the words would have become, where they appear in subsection 3, if section 5 had provided for citizenship in the same terms, where they appear at assumption A, it would be open to the court to interpret those as permitting consideration of the hypotheticals which arise in terms on the application of the assumption and which directly involve discrimination. But it wouldn't go as far as to permit consideration of hypotheticals which are purely incidental to the other requirements of the provisions. Because those incidentals take, for example, the mother who might have stayed longer in northern Rhodesia or might have remained in Crown service. Women in that circumstance were not, as a matter of fact, prevented from doing that. They could have stayed in those. And the same logic would apply to the third condition at subsection 4. So it would be open. There is at least a route to interpretation which would leave it open to consider the past hypothetical under 5.1b, but to disregard any further hypotheticals and to draw the line at consular registration only. Now, as I say, my submission, for the purposes of this interpretive process with which we're engaged, I don't submit that that's necessarily the result which would have to be reached. I simply my submission is an alternative to saying, well, it is a possible route which the court would be open to go down to saying, well, consular registration, we can consider that. Beyond that, no. But the primary position, which I've, I think, responded to, is to say that if I'm wrong about that, well, so be it. Those other past considerations can be determined in the same way as consular registration can be. The court will allow me a moment just to remind myself of where
you are, because we took you out of your course.
That's, of course, lady, but perfectly well understood. I think where I was if I drew back to subsection 3D, I think I was still in the midst of subsection 3D, and I was about to draw to the court's attention, or about to address the question of the further point I was making about the reference to other requirements in terms of subsection 3D. And the point the question that I was posing was, what effect does that have for the overall interpretation of section 4C? And in my submission, it comes to the point that it poses a difficulty in my submission for the appellant, however one looks at it. On any view, Parliament plainly did not intend subsection 3D simply to apply to the provisions relating to consular registration. As I've already indicated, the natural meaning in my submission of other requirements of the provisions is simply everything else that the provisions required. So it would include Crown service and so on. On the appellant's case, of course, the ultimate consequence of subsection 3D is that it has a different effect in relation to consular registration as compared with the other requirements. But if that is the case in my submission, it is curious that subsection 3D does not in terms treat the requirements relating to consular registration any differently as a matter of language to the other requirements. So what the appellant contends for in terms of subsection 3D is a different outcome in relation to different provisions referred to within section 4C, but without using different words in subsection 3D. And in my submission, that is a factor which supports the respondent's interpretation. The further point that I make in this regard is that it's just to highlight the effect, and to some extent I've touched upon this already, but simply to highlight exactly how the appellant comes to what they say the effect of subsection 3D is. Because the point that is made is that, in effect, 3D on the appellant's view makes clear that it is for the applicant to establish the factual prerequisites to obtaining citizenship. And as I understand it, the appellant accepts that that must apply because of the reference to other requirements. That must apply to all of the requirements, whether it be consular registration or whether it be Crown service or so on. It simply so happens that when one comes to consular registration in terms of section 5.1b, it is impossible to establish it. It's possible to establish it because it could not have occurred as a matter of law at the time. And in my submission, the absurdity in that approach is that the only reason why consular registration could not have been effected lawfully at the time was precisely because of discrimination. In my submission, the appellant's approach is one which perpetuates discrimination. It excludes 5.1b from the scope of the remedy because it couldn't have been achieved at the time because of the existing discrimination. And in my submission, that is to be understood as being entirely contrary to the overall aim of section 4C. And it really draws, I suppose, one back into consideration of a point which has already been discussed, which is that the appellant's position is that one must assume the law to be different, but the facts to remain unchanged. But what then of any mothers who, as a matter of fact, did manage to consularly register the birth? And it appears that before the House of Lords at the time of these amendments, there was evidence that there were at least some mothers to that effect. And I think the court will see reference to that in the letter from Lord Brett to Lord Avebury and the other members of the House of Lords. It's to be found at tab 7. It starts at MS 150, and the reference which I draw the court's attention to is at MS 152. And
Yes, the point is made in Branson's book, page 479, where that letter is quoted.
And it's in particular in Lord Brett's, and for the avoidance of doubt, I rely upon this not for the purpose of course, like Mr Johnson, I don't rely upon anything that was said in Parliament in terms of an aid to statutory interpretation. I simply draw this to the Court's attention to make clear that the House of Lords appears to have evidence that there were mothers who effected consular registration. And one sees that in the third paragraph from the foot of the page at MS 152. It said, in our recent discussions, it has been suggested that mothers unable to transmit their citizenship status under the 1948 Act may not have taken action such as consular registration of their child born overseas because they would divine no practical benefit from doing so. However, some women who gave birth to children in some such circumstances did in fact consularly register their child. That child would now be caught by the parameters of Section 4C. Now, leaving aside that last comment, which is effectively, one could take statements that were made in either direction in the overall parliamentary material that's before the court. But as a matter of fact, the House of Lords seems to have been aware of mothers who fell within this category and were able to consularly register. And the question becomes then on the appellant's case, how is one to regard those mothers? They're either excluded, and they're excluded together with everyone else, or they're included on the arbitrary basis that I've drawn to the Court's attention. On any view in my submission, it would be an odd result. So for all of those reasons in my submission, subsection 3D, well, of course, except it is an unusually worded subsection. It is not one that permits of easy reading, but it is one in my submission on the whole is to be taken as not assisting the appellant, and on the contrary, it should be understood as having been inserted for a reason which positively assists the respondent's interpretation, in effect in an attempt to clarify a matter that might otherwise have been left unclear. In a sense, again, I draw the Court's attention to the overall aim of Section 4C and to the point I think I made in response to my Lady Black's question. This is in the context of amendments to widen the scope of Section 4C. It would be a very odd result indeed if subsection 3D in isolation against the wholesale incorporation of Section 5 earlier in the section were to be taken as having this narrowing effect contrary to the overall aim of Section 5. I intend to move on to the question of the differential treatment. I wonder if that might be an appropriate time to break.
Well, if that's what you would like to do, if that's convenient.
Certainly about to move on to an entirely new chapter.
It's a few minutes early, but we're doing well for time, so that's we're happy to adjourn if that would suit everybody. We look forward to hearing from you further at 2 o'clock.